My name is Hester KROEZE. I am a PhD candidate at the Ghent European Law Institute institution, and the title of my contribution is Parent-Child Relationships in EU Free Movement Law. The definition is important to shape obligations between children and their parents and the member states' nations. The member states provide support and protection, facilitate family life and education. But who gets the entitlement? That depends on the content of the right or the privilege at stake, whose definition is shifting, so the shape of the parent-child relationship changes along. EU law is bound to the division of competences and can only define beneficiaries of EU rights. So defining the family for EU law commences in the context of free movement rights. Free movement is connected to family reunification, which facilitates EU citizens to exercise their assigned rights because nobody wants to leave their family behind. This impacts member state discretion, so it is important to be persistent and precise because member states might take offense if the price of free movement rights is too high and their competence is too concise. So family reunification is preserved for partners, parents, and children, for family in the first degree regardless of their age, for descendants and ascendants as long as they are dependent. But how is this relationship defined? Is it dependent on legal or biological bloodlines? For that matter, EU law is inclusive. As long as there is family life, it will not be intrusive. The definition in the Citizenship Directive is decisive. Biological and legal relationships are entitled to residence, as well as relationships between children and step-parents. Only when neither of the parents is by blood or legally related, the system gets frustrated, and another possibility must be created. As a result, children placed under kafala who are unblooded cannot be included in the EU parent-child relationship alluded. They are, however, not deprived of all rights. Their access must be facilitated, weighted, debated, all the circumstances must be stated, and where dictated, a residence right must be created. Might other caretakers be derisive? They should not be concerned, because their care for a child is decisive. If the care they provide require an EU citizen to remain at their side when they depart and backslide into the worldwide and leave the European Union behind, then EU law is gracious, spacious, and pragmatic to say that the caretaker is allowed to stay. The Luis Zambrano case provided this rule and provides non-parental caretakers with some tools. Then how does this work for the protective role? The European Union's goal to protect and preserve, facilitate and serve the contact between parents and their infants, so they need not be at distance or find any hindrance to preserve the relationship between them. The authorities can be of some assistance when the other parent offers resistance. International law forbids to disturb the contact between parents and their kids. Article 9 and 10 of the Children's Rights Convention is where these rights are mentioned. And Article 24 of the EU Charter makes interference with these rights even harder. But what does it mean? Who does it include? The provisions only speak of parents without definitions. Might they be legal and biological as well? And other caretakers? Are they included by lawmakers? Might the Luis Zambrano logic be used analogically? What is left are supportive rights, child benefits and education, but these are within the competence of the member states and only bound by non-discrimination. Member states are not obliged to concede, but if they do, they must agree to be honest and provide it to everyone who needs help, equally, evenly, dreamily, and frequently. The definition of family members must be the same for nationals and EU citizens from other member states who aim to claim the same rights when they pertain to the same situational circumstances and their status allows them to equal entitlements as parents, whose presence is an insurance for the well-being of the child and its cultural inheritance. So to briefly conclude, the definition of the parent-child relationship is subdued to the legal field that is relevant, the rights that are pertinent, what by the division of competences is compelled, as long as the European principles are upheld.